Discussion on the legality of income and Social Security taxes. Today, a panel of former IRS officials, public policy representatives, and attorneys talked about the history of taxes in the U.S. and the constitutionality of the government at being able to tax its citizens. This 3-hour event was hosted by We the People Foundation for the Constitution Education.
Good morning.
Good morning.
Ladies and gentlemen. Welcome to the second day of our symposium. The title of our symposium is, Are the Income Tax and Social Security Taxes Legal? And if not, what then? The symposium is being sponsored by the We the People Foundation for Constitutional Education, which is a New York not-for-profit corporation under Section 501c3 of the Internal Revenue Code. And my name is Bob Schultz. I am chairman of the foundation. As the title of the symposium suggests, we are here to examine the question of whether the federal income tax and Social Security tax are legal, and if not, what then? The way this came about was that the foundation last winter began to become aware of and to get acquainted with the work and the ideas of a number of people from various parts of the country who have been for years been researching, writing, and speaking out about their beliefs that the federal income tax as we know it is not legal and is not being administered legally. It soon seemed like there needed to be an organized meeting of some sort in order to get some of these people together to talk about their work, present it to a concerned audience, compare and contrast their views, and challenge the government to debate with them the key and crucial questions on their merits without evasion. The We the People Foundation for Constitutional Education is an educational, not-for-profit corporation whose purpose is oriented towards information, research, and education, and in fact, we are restricted to that realm by our charter. The foundation has not taken a position on the question of the legality of the income tax, except a position that it's a very interesting and important question, and that there's been some very impressive work done on it. We decided that the proper format for the meeting would be in the general style of an academic symposium, combined with opportunity for debate in sort of a point-counterpoint concept. A scholarly format is a good way to assure that the best ideas will float to the top. Since the IRS has chosen not to respond to our request to identify their most knowledgeable people and to have them participate in this symposium to argue against the conclusions of the researchers, we are providing you in your packets as a substitute a collection of written arguments that have been used by the government in defense of the income tax. These will be discussed later on, and I'm sure the speakers will be addressing them during their presentations. Now, the overall question of the legality of the income tax is approached at this symposium in terms of two propositions. First, that the 16th Amendment was not legally ratified. Indeed, was fraudulently declared to be ratified by then Secretary of State Philander Knox in 1913. And two, second, regardless of the 16th Amendment, that there is neither law nor regulation that requires most citizens to file returns and pay income taxes. We recognize that there are a variety of views represented by the participants here, and that they don't all see eye to eye on all points. However, the most important common ground is that it appears that they all agree with the conclusions that most citizens are not legally required to file returns and pay income taxes, and that laws are being applied illegally. We want the speakers to present their ideas and findings in a positive fashion, propounding their own views, not focusing on their differences. That's the job of the government. As I say, we think the best ideas will rise to the top on their own merits. We have, obviously, the question, if the income tax and Social Security tax are illegal, what then? There are many ideas for tax reform. Some of the country's most prominent people have their own ideas in Congress and outside of Congress for tax reform. One of those organizations is the Heritage Foundation. We're pleased to have Dan Mitchell, a senior economist at the Heritage Foundation, with us this morning to discuss with us one such alternative to the income tax, a sales tax. We'll be hearing from Mr. Mitchell later on. So we're here to discuss whether the income tax and Social Security tax are legitimate, or are they a hoax? If a hoax, it's ironic that the first income tax was during the war between the states. Ironic because it was Lincoln who said, you can fool some of the people all of the time and all of the people some of the time, but you can't fool all of the people all of the time. If today's income tax is a hoax, then we don't want to be fooled any longer. And we don't want the rest of the people to be fooled either. We've asked our participants to be as specific as they can in order that the IRS's arguments will have as little wiggle room as possible, and to respond to the government's arguments that way as well. In looking over the government's written positions, it seems like the pea is always under some other shell. We want to eliminate or exhaust all of the shells. That's one of the advantages of having researchers here who have come at this from different angles and backgrounds. Now, we're pleased to have with us as our first speaker, panel member, Bill Benson. Bill Benson in the 1970s spent 10 years as a criminal investigator with the Criminal Investigation Division of the Illinois Department of Revenue. He was let go, fired by the department for uncovering corruption within the department. He sued the state for violation of his First Amendment rights and won a large judgment. He began assisting an attorney in a significant tax case. In June 1983, he was assisting attorney Andy Spiegel in a willful failure to file case. He had 300 documents showing, at that time, serious problems with the 16th Amendment, the so-called income tax amendment, purportedly ratified in 1913. But the judge in that case would not allow Mr. Benson to submit those documents into the record. Undeterred, Bill Benson took then 1 year studying, going to all 48 states, going to the archives of the 48 states that were in existence in 1913, obtaining certified copies of their records, and he determined from those certified copies that, in fact, the 16th Amendment was not properly or legally ratified. It gives me pleasure to introduce Mr. Bill Benson.
Thank you, Bob. Thank you for having me here this morning. And thank you, ladies and gentlemen. I have waited a long time to bring this issue before the cameras, before the courts, in fact, 15 years. As Bob told you, when I was fired by the Department of Revenue for the state of Illinois for undercovering corruption, the director and I did have a very heavy dispute, and I told him I would sue him, and that I did, and won a large judgment against the state of Illinois. So bear in mind, David can beat Goliath. In June of 1983, I began to assist an attorney in Chicago by the name of Andrew Spiegel. We had a willful failure to file income tax case, and we had approximately 300 documents showing that there was a very, very serious problem with the 16th Amendment to the United States Constitution, which gives the government its taxing authority over all of us, over all Americans, to reach into your pocket, reach into your wallet, reach into your bank account, seize your cars, seize your homes, and etc. I hope and pray that I can put this to an end. I am making every attempt to do it, and I did that by going to all 48 states, all 48 continental United States in 1984, spent an entire year on the road doing nothing but research for the government or against the government. I knew full well, because of my past experience, that if I did not bring back the proper documents, the government certainly would then dispute me, certainly would win. I can tell you now that since 1981, I, Bill Benson, have not filed a personal income tax return. I can also tell you, ladies and gentlemen, that I, Bill Benson, absolutely, completely refuse to file a 1040 tax return if I were given a job that paid me $1 million tomorrow. Because with the research that I did for the entire year of 1984, I came back with 17,000, probably in excess of 17,000 certified, notarized documents showing and proving that the 16th Amendment to the United States Constitution is an absolute, complete, total fraud. And I tell you that I will not file a 1040 tax return because this man is not going to permit the federal government to make him a criminal. For if I file a 1040 tax return under 18 U.S.C. 1001, I become an accessory after the fact to the crime committed by Philandro Knox back in February the 25th of 1913, and I refuse to do that. If government cares to come after me and indict me, then let's get the show on the road. That's the purpose for meetings like this. That's the purpose for being on television. The government is welcome to look at this. I'm sure they have, because in fact they have a copy. The federal courts in Chicago have a copy of all 17,000 documents, one for a judge and one for a prosecutor. The vote goes on to tell us that there were 9 senators that voted for the amendment and 22 against it. Now, I ask you, ladies and gentlemen, all over this country, when in your wildest dreams or comprehension will 9 ever become greater than 22? If any judge can make that happen, I'll march off to jail tomorrow. or I'll file a 1040 tax return. He can't make it happen. They cannot get by the documentation, and that's why I am as secure with my position as I am. And that's why I can challenge the government as I do. In some of the documents, one of the documents that I found in the National Archives in Washington, D.C., that was authored on February the 25th of 1913 by Reuben J. Clark. He was the attorney for Philandra Chase Knox, the Secretary of State at that time. Philandra Knox wanted to know how the amendment was adopted. And I believe that his attorney gave him some very good advice, because what he said, in the certified copies of the resolutions passed by the legislators of the several states ratifying the proposed 16th Amendment, it appears that only 4 of those resolutions, those submitted by Arizona, North Dakota, Tennessee, and New Mexico, have quoted absolutely accurately and correctly the 16th Amendment as proposed by Congress. No state legislator can change one word, can change one punctuation. They cannot change capitalization. They cannot change a period or a comma, because if they do, it does not meet with the requirements of the Congress of the United States, and therefore it must, absolutely must be rejected. I found that to be very true, because when I was researching the 16th Amendment, I also researched the 17th Amendment. In the state of Wisconsin, William Jennings Bryan was then the Secretary of State, and William Jennings Bryan rejected the state of Wisconsin's ratification because they had added a paragraph and changed the wording in the body of the resolution adopted by the Congress of the United States. There were telephone calls that were made back and forth. The Secretary made one to the governor. The governor says it's a fortunate thing for us that the General Assembly is still in session, so maybe I can call them back together and we can change it if they want to conform with the wishes of Congress. Otherwise, it will have to be rejected. You see, at that point in time, the legislators for the various states only met once every 4 years. Once every 4 years. Not like today, a profession like they have, and meet once every 4 split seconds to go ahead and enact some new crazy law for us to be binded by. They go on to also say that the other 33 resolutions all contain errors either of punctuation, capitalization, or wording. Remember the date, February the 15th of 1913. It says, Minnesota, it is to be remembered, did not transmit to the department a copy of the resolution passed by the state. I found that extremely interesting. When I went to Minnesota, I found my answer. And I also found my answer in the 16-page memorandum that any one of you can go to the National Archives and get a copy of. It says on page 16 that the department has not received a copy of the resolution passed by the state of Minnesota, but the Secretary of the Governor has assured the state, the Secretary of the United States, that the amendment has been adopted. The Secretary of the Governor? I beg your pardon. Cannot happen, will not happen. The Secretary of the Governor cannot sign a document like this. Absolutely cannot. Has not that power to do so. And it's a good thing for us that they do not have the power to do so. There are 11 states, ladies and gentlemen, that failed to vote, failed to vote on the 16th Amendment to the United States Constitution, it is still tabled. It's on the table today. There was a 7-year cap on the 16th Amendment, so I give a hang what they do today. They can't vote on it. It makes no difference. Congress likes to give us big arguments. Well, 16th Amendment was brought before the Congress of the before the Supreme Court of the United States, and the argument was lost. Not this argument. Not the fraudulent act of Philander Chase Knox has never been before a jury or before a full panel of the appellate court, or with all the 17,000 documents that I possess, the 2 books that I authored, Volume 1 and 2, has never been brought into district court, ever. You know the reason why? They've got the jury to deal with. And you, ladies and gentlemen, in this room and in this country are the jury. When will 9 ever become greater than 22? Never. To prove a point, in the Chicago Tribune on January the 10th of 1985, there was a young man that was arrested for selling PCP, angel dust. There's a law that says you can't do this, but the law must be enacted correctly. His lawyer was very, very sharp, very shrewd. He went to the inception of the law, like I did with the 16th Amendment, to find out if the legislative body had enacted that law correctly. And what did he find? He found that an F was substituted for an E in the code, naming a revised section dealing with PCP. The young man flew like a bird, and so did his lawyer right out of the courtroom. They lost the case. Now, I hope you can understand why they fight this 16th Amendment issue as hard as they do. There was a report written on April the 18th of 1980 by the Congressional Research Service. And the Congressional Research Service tells us here in Washington, D.C., that arguably 2 requirements seem to be legally indispensable in a valid ratification resolution. The first is that the resolution contain in full the exact language of every section of the proposed amendment as it appears in the enrolled joint resolution proposing the amendment. They knew it back in 1913, and they know it to this day. Let one of them in the Congress of the United States, or all of them, pass an amendment to the Constitution, and let the states do what they did with the 16th Amendment, it'll go out the window like that, without a question of a doubt. When I was in Boston, I found more proof. Because you see, when you're an investigator, when you've gone through court, when you've arrested people, when you've had to prove your case, you better be right or you're going to get sued. In the report in Boston, there was a question that was asked by the committee. Are we able to change it? And the answer came back by Senator Luce, no. We must either accept or reject it. This was in 1910. Again, Washington, D.C. How our laws are made, extremely, extremely important. Because they must follow. The Congress of the United States must follow the laws as we must follow. If the 16th Amendment were adopted correctly, I would not be standing here before you today and telling you that I will not file a 1040 tax return and permit the federal government to make me a criminal. In the how our laws are made, it says each amendment must be inserted in precisely the proper place in the bill with the spelling and punctuation exactly the same as it was adopted by the House. They have got to. Otherwise, what will we have? Chaos. We'd have 48 different versions of any amendment that the United States government tried to have the legislators of the various states adopt. They must do it exactly, precisely, as wished by Congress. In the proclamation by Philander Chase Knox that was written on February 25th of 1913, he said that it appears, when you go into federal court and you argue with the judge, hey judge, it appears that I'm right and you're wrong, find out how fast you'll go to jail. Or find out how fast you'll get fined. Or find out how fast that judge will do whatever is set in his mind to do to you. It cannot just appear. It must be exactly, precisely as the Congress of the United States wished in any amendment. I wish I had the time to look up all of the amendments. I don't know what I would find. I'm rather afraid to do that. I told you that there were 11 states that failed to vote on the amendment. And in another, I had it put in the back of Volume 1, ratification of the Constitution and amendments of the states, presented by Mr. Fess, United States Government Printing Office, 1931. What they did was the Congress of the United States wanted to know how all of the amendments were adopted, each and every one. With the 16th Amendment, they listed the names in alphabetical orders as far as the states are concerned. They listed the yeas and nays and the percentage, and then they come up with a cute little word called passed. And when I would talk to people about this, they would say, passed? Bill, what are you arguing about? Passed means they passed it. Look in your dictionaries, each and every one of you that's listening to me today. Passed means no. Passed means to go around. Passed means to circumvent. Passed means to pass it by. That's why there are 11 states that are still tabled to this day that have failed to vote. It takes 3/4 of the states to ratify any amendment. We're so far under that 3/4, it is pathetic. That's why I can so boldly say what I do on television, on radio, before anyone that I speak to. How our laws are made, any one of you, any congressman, call your congressman, tell him, give me a copy of the book. You want to see it. You want to see the book on the 16th Amendment to the United States Constitution in the National Archives. It's a very heavy bound book. It's beautifully bound. You cannot photocopy it. So what I had them do was to bring in a man that would go ahead and make it camera ready. He copied it with the camera. And then the archives went ahead and they certified it and notarized it. All the pages in the book. I said, I want every page from the front to the back. I don't care if there's a little squiggly mark on the back. I want it. He says, Bill, do you understand what this is going to cost? I said, I didn't ask you about cost, because at that point in time, cost was no object. And I got what I wanted from the National Archives in Washington. Today, I have heard it said, and I hope that I'm wrong, that you cannot get the documentation that I got because they will tell you they do not have a supplier to give you the information that you want, that I possess. I also have 3 sets of microfilm. I left no stone unturned in this 16th Amendment issue. It is the 16th Amendment to the United States Constitution is by far, ladies and gentlemen, the worst thing that the Congress of this United States could continue to let go. And it takes people like people in the camera audience, people in this audience, all over the world, to call your congressman, to write them, to do anything that you have, and say, bring Bill Benson to court and prove him wrong, or stop taking money from my pocket. Stop taking money from my back pocket, from my wallet, my car, my house, and etc. That we, the people, will no longer stand for it. If I can stand up as one and win a large lawsuit from the state of Illinois with a lawyer that was fresh out of law school, give me the opportunity, Congress of the United States, the Justice Department of the United States, to prove those 17,000 documents wrong. The federal government in Chicago has had those 17,000 documents for 18 years. Federal Judge Paul Plunkett and United States First Assistant United States Attorney and Deputy United States Attorney Joan Bainbridge Safford has also had a copy of those 17,000 documents that are certified and notarized. I had to make them. I could not send them out and have them done anywhere else. Because if that ribbon is broken, if the seal is broken, or any part of this front page is defaced, it is null and void. It is no good. You could not use it in court. That is my evidence, ladies and gentlemen, and I thank you, one and all.
And thank you, Bill. Joe Bannister is believed to be the first Internal Revenue Service Criminal Investigation Division special agent ever to discover alleged wrongdoing in the administration of the federal income tax and then confront top officials in the Internal Revenue Service about those allegations, and his belief that taxpayer rights were being violated. After confronting top Internal Revenue Service officials, his inquiries were summarily rebuffed, and he was encouraged to resign. He received a note from his superior. Joe, take 7 days off, clear your head, When you come back, if you still feel the same way, resign. Joe resigned on February 25th, 1999. Mr. Bannister is a graduate of San Jose State University. He became a licensed, certified public accountant, senior tax accountant with one of the large accounting firms. In 1991, he left that profession of public accounting. In 1993, he accepted appointment to the U.S. Department of the Treasury, Internal Revenue Service, Criminal Investigation Division, as a special agent, a criminal investigator. In addition to his investigative duties as a sworn federal law enforcement officer, Mr. Bannister was the Organized Crime Drug Enforcement Task Force and Asset Forfeiture Coordinator for the Internal Revenue Service Central California District. He also assisted with firearms and defensive tactics training, as well as community outreach. It's my pleasure to introduce Joe Bannister.
Thanks, everybody. Well, this is the same group that I spoke to yesterday, but somehow with these lights and cameras, it tends to make your heart flutter a little bit more. Well, Bob's basically done a good job of explaining to you briefly where I came from and what I did before I worked for the IRS. But I will say that in 1991, when I became a CPA, I had this insatiable desire to get into law enforcement. It was a burning desire, a desire that I just could not get rid of as much as my wife would have liked me to. So in 1991, I applied to both the FBI and the IRS to become a special agent in either of those two agencies. The FBI, unfortunately, didn't work out because there was a hiring freeze that lasted a very long period of time, and I was not able to get hired by them. But in August of 1993, the IRS Criminal Investigation Division gave me a call and asked me if I'd be interested in working for them. IRS special agents investigate violations of the federal income tax and money laundering laws. And although I kind of had my heart set on being an FBI agent, I went ahead and interviewed for the position. And actually, after my research, I found it to be, it sounded like a very exciting job. So after August, it spent August, September, October, November. There was a long period where I had to go through a background investigation. They check you out quite thoroughly because you'll be holding a position of public trust, and they want to make sure that you're worthy of holding that position. So finally, in November of 1993, I was sworn in as a special agent for the IRS Criminal Investigation Division. I spent the next 3 years in the IRS Criminal Investigation Division, or for short, CID, and I had the most satisfying career to date. I really enjoyed the work that I did. What I thought was interesting is that up until that point, I would always look at my watch, wonder when 5 o'clock was going to come or 6 o'clock, because I really wasn't as happy or fulfilled being an accountant. But during those 3.5 years in the IRS CID, my first 3 years, I very much enjoyed the job. I worked on very exciting criminal investigations, illegal drug smuggling, tax evasion from very big people that cheated on hundreds of thousands, if not millions of dollars, money laundering investigations. I very much enjoyed the job, and of course, I still believe that when people cheat on their taxes, taxes that are mandatorily paid and due and owing, that they should be investigated and punished. You remember from yesterday that I get a dry mouth really easy? I really enjoyed myself. I brought something I didn't bring yesterday. I wanted to show you when I went through training at the Federal Law Enforcement Training Center. I was elected president of my training class. And I don't know if it's big enough for you to see, but it's a federal agent type guy with his dark glasses and fedora. And it says, "I'm your worst nightmare, an accountant with a gun." And that's basically what IRS agents, special agents, were considered, accountants with guns. We have a lot of financial expertise. I'm still saying we, like I still work there. But I still do have a lot of pride in that law enforcement profession, and have a lot of friends in that area. Anyway, I guess here's a second shirt. I used to wear this on search warrants. I was very proud of my job. As I say, I enjoyed it very much. But unfortunately, in December of 1996, my career euphoria started to take a bit of a downturn. I was listening to a talk radio show out in San Francisco, California. It was hosted by a man named Jeff Metcalf. And Mr. Metcalf had a lady on his show named D.V. Kidd. And actually, D.V. Kidd is one of the panelists here. And I believe that day I was driving around in my government car with my gun and my badge and thinking I was doing the right thing. And D.V. Kidd was on the radio saying what at the time sounded like very unbelievable and outrageous allegations. She was saying things like the federal income tax is voluntary for most Americans. She was saying that the 16th Amendment to the U.S. Constitution had never been legally ratified. And she said that the money that we pay in income tax, federal income tax, does not go towards providing revenue for the U.S. government to operate. Well, I'm sure you can imagine that I didn't really like what I heard. But because she was on Jeff Metcalf's show, a man who had established credibility with me in the past, I went ahead and ordered books that she offered on the radio, Why a Bankrupt America and Blind Loyalty. So that was about December of 1996. I spent upwards of 2.5 years researching the information that Ms. Kidd put in her booklets. And she referred to a number of individuals in the booklets. And interestingly enough, she would put the telephone numbers of the people with this evidence about these allegations that she mentioned on the radio right in her booklets. So I thought to myself, well, you know, I'm an investigator. I use the phone quite often to perform my investigations. I'm going to call these people and just ask them. And that's exactly what I did. So over a period of approximately 2.5 years, from about January of 1997 when I received D.V. Kidd's booklets until February of this year, I spent researching and trying to disprove the allegations and claims that she made about the federal income tax, 16th Amendment, where our tax money goes, those kinds of things. The first person I called was Bill Conklin, who will be speaking shortly. And believe it or not, I took the day off work and I called up Mr. Conklin and I said, hello, my name is Joe Bannister, and when I'm taking the day off, but when I'm at work, I'm a special agent for the IRS Criminal Investigation Division. And I've read some of these very, very unbelievable allegations in D.V. Kidd's books, and I'm not quite sure why I'm calling you. I guess I'm basically trying to disprove what she's saying. Now, I expected Bill Conklin, because as I was reading these books, I'm getting this mental picture of what the IRS had always told me a tax protester, quote unquote, was like. You know, drooling, incomprehensible, you really can't understand what they're saying, they're not making any sense. And as you'll see soon when Mr. Conklin speaks, he doesn't drool at all. And he's actually a very, very educated and intelligent man. So anyway, over a longer period of months, I found out that contrary to my perception or belief, the information that he provided me was actually very credible, and it made a tremendous amount of sense. His issue deals with the Fifth Amendment and the filing of federal income tax returns, and I won't go too deep into it. I'll let him let the expert talk about it. But obviously, after talking to Bill Conklin, I definitely got a feeling that he was making some sense, and maybe there was something to these allegations that D.V. Kidd published. So the next person I moved to in D.V.'s book was a man named Bill Benson, who you've just heard speak. And Mr. Benson, as you saw, definitely has some very compelling evidence that the 16th Amendment was never ratified. Again, contrary to my perceptions, I thought that I'd be talking to somebody that, if he wasn't drooling, he was certainly not making any sense, totally incomprehensible. That was my expectation. But as you can see, Mr. Benson was a professional investigator himself. He has moved heaven and earth to try to inform the American people about the 16th Amendment issue so that it gets debated and discussed. Then I called D.V. Kidd and told her that I was an IRS special agent from the Criminal Investigation Division. So, of course, she said to me, "Yeah, right." But eventually I was able to prove that to her. And so her basic question to me was, what are you going to do about it? And obviously, that was a tough question, because that's exactly the kind of decision that I had to come to, was what am I going to do about it? And what I did was I went back and basically reflected, and I didn't do this all in 5 minutes, but I reflected over a long period of time about what really had meaning to me in life. And I thought about the Ninth Commandment, which forbids us from bearing false witness against our neighbor. I thought about the Constitution that I had sworn an oath to support and defend. I thought about the IRS mission statement, which speaks of collecting a fair amount of tax with integrity and fairness, helping taxpayers to understand and meet their tax responsibilities. I basically looked at the guideposts in my life to help me determine what I would do next. Besides take another drink of water. So what I decided to do was to accumulate all of my own research and proof in a report that was very similar to the kind of report that I would do as an IRS special agent. Accumulate the facts and the evidence and basically come to a conclusion, or at least a recommendation on what to do next. Well, when it came to be early 1999, and I felt that I had researched this as much as I possibly could and was comfortable enough and confident enough in my own research that I could take a position, take a stand, I did so, and I decided that I was going to actually submit that report that I prepared to my supervisors. And I'm sure you can imagine that was quite a leap for me. It took a lot of soul searching, because I knew, I just had this feeling that the IRS and my supervisors all the way up the chain would not be very positive about what I had to say. But still, I had these convictions. I had all of my guideposts to rely on, my faith in God, and I just thought, I've got to do this. I have to ask these questions. I've sworn an oath to support and defend people's rights, and whatever adversity may come my way, I feel that I have this duty, and I need to earn my pay. So on February 8th of 1999, I submitted my report to my immediate supervisor, and by February 11th, my supervisor's boss, who was the chief of our Central California division, called me into his office, and to say that he looked at me like I had two heads would probably be an understatement. he said to me, are you really serious about this? Because what I had asked on February 8th was that my report be submitted not only to my chief, but all the way up the chain to Commissioner Rosati here in Washington, D.C. I respectfully requested that they review my evidence and show me the error of my analysis, if any. I really sincerely needed some guidance. And at that point, although I had spoken with the various people on the panel and others, I was not doing anything publicly about this. I wanted to get answers to my questions because I was issued a gun and a badge to put people in jail and when called for, shoot someone. I mean, I had the authority to use deadly force. Carrying a gun, I would think I would at least need to know what the laws I was enforcing were all about. So I did present that evidence to my supervisors, and from February 11th to February 17th, didn't hear anything. I went ahead and just did my job as I had always done. And then on February 17th, I was called into my chief's office again, and I was given a memorandum. And actually, I should back up because I always forget this part, but when I submitted my report on February 8th, I told them that if they were not able to show me the error of my analysis, then I'd be forced to resign because I could not serve two masters. I believed that the Constitution and the income tax and all was all one, and I wouldn't have any push-pull or conflict between the two. And I had now come in contact with that conflict and needed some resolution. Well, on February 17th, I was issued a short memorandum which stated that the IRS as an agency would not be responding to my report. They also told me that they would provide me with the necessary paperwork to tender my resignation. And the last thing they told me was that I was to be placed immediately on administrative leave for a period of 7 days to think about what I had done and what I was going to do. So that day I turned in my gun. They didn't take my badge from me, but they took my gun, and I spent the next few days on a paid vacation, I guess you could say, to think about what I was going to do. On February 25th, which happened to be my birthday, and I believe it also happened to be the day that that Philander Knox proclaimed that the 16th Amendment was ratified. Things are all kind of coming together, and I resigned from the IRS Criminal Investigation Division. And the reason I resigned is obvious. I received no response whatsoever from the agency. And I can tell you now, as I've told many people, I had a sincere and still do a belief that if you're a federal law enforcement officer and you swear an oath before God to support and defend the Constitution, and sooner or later you just might have to do that. And I took it seriously, and I took my job seriously. I'm sure if anyone were to check, they can see that I did very well as a special agent and investigator for 5.5 years. But the career, which I thought would last my entire working life, was cut short. Well, because of the lack of response as a federal agent and the fact that I then had to resign, of course I had to start thinking about what next? What am I going to do to spread the word about these things? Because although I may not be under a duty based on my oath as a federal agent, I still have a duty as a citizen, as a father, as a husband, and again, the 9th commandment will bind me for the rest of my life. And so I felt that I had to start speaking up about the fact that the IRS chose to ignore me. When you consider that they could have made me look like a complete fool, or they could have shown me the error of my analysis and made me a spokesman for the rest of my career to explain to people how I was fooled by the likes of Bill Benson, Bill Conklin, D.V. Kidd, Larry Beecraft, to me, those would have been a couple of great choices for them. And they chose neither one of them. They instead chose to ignore me. And as you may have heard earlier, or actually all of you saw yesterday, that we tried to get the government to come and talk about these issues face to face, and they didn't send anyone. So basically what I've done since February 25th is I've established a website, which is freedomabovefortune.com. And I've had 70,000 visits to that website since March 1st. And I'm not advocating that people not pay tax or not file. What I'm advocating is that people educate themselves so that they can learn what the dividing line is between your money that you work so hard for and the government's money. What are the legal lines in the sand for how much of your hard-earned money you keep? Because after all, isn't that what the purpose of our government is, or at least it used to be, was that they protect your rights and your property, not come up with schemes to deceive you into losing your property or to take your freedom. So I hope that people will visit my website, freedomabovefortune.com. There's a lot of links there. I want to educate people, and I certainly want to state that the people on this panel I found to be very credible, very trustworthy, that their intentions are sincere. They are not out to make a buck. They're out to they've been trying to show people for 15, 20, 25 years that there are some serious issues going on with the federal income tax, and there's a lot of deceit that's going on. And they are labeled as tax protesters and right-wingers and extremists. And at least speaking for the group here and the other people that I've spoken with, they are not that at all. They're trying to inform the American people that there's some big problems with the federal income tax. And it's about time that we do something about that. Thank you very much.
Thank you, Joe. I should tell you that as a talk show radio host at WRW in Albany in February, you get ready for an afternoon show. You go to the internet, you search, you read your email, etc. And in February, something crossed my screen. Just a brief reference, somebody sent me an email about this IRS agent in California who submitted a report to his superiors. His superiors didn't answer his questions, and he resigned. And that his report and his questions went to the heart of the income tax. Now, when you're a talk show host, you're looking for material. And I said, this would be interesting material. So I had a producer locate Joe Bannister, and we called him at home, and I interviewed him, and he sounded credible, laid back, and he said that his work was available on the internet under Freedom Above Fortune. Found that impressive, that he made his 95-page report available for all of us to see and to come to our own conclusions about. And I'm trained as an engineer and have done a lot of research and report writing, and I was struck with the soundness, apparent soundness of the report. Very credible document. So I had Joe on the show, and of course his report, and Joe led me to Bill Benson. I called and spoke to Bill, got a copy of his report, had him on the show. Same with Bill Conklin. It became very obvious to me in my role also as chairman of this educational constitutional foundation that the situation is intolerable. we have to get to the truth. On the one hand, we have this very substantial body of very credible evidence that there is no legal foundation, no authority under the income tax to support the income tax, beginning with the 16th Amendment, then the statutes. And yet there are a growing number of people who are losing their homes and going to prison because of the enforcement of a law that may not exist, may not be valid. And so we have arranged this symposium to try and get to the truth. And we had sent to the President, to Senator Lott, and to Senator Hastert, Congressman Hastert, and to the Commissioner of IRS, a copy of Joe's report, a copy of Bill Benson's 2-volume work, and a copy of Bill Conklin's report, and very respectfully asked the heads of our political branches to identify their most knowledgeable people to come and participate in this symposium and to argue against these conclusions. Very respectfully requested them to do so in early May. No response until June. On June 7th, we sent a follow-up letter. No response. Absolutely no response. The material was sent certified return receipt requested mail. So here we have an IRS agent, having done his research, submitting his reports and his findings to his superiors, asking them respectfully to respond to the evidence, the facts, and being ignored and forced to resign. And we've done the same thing with the government. No response. It's the rule of law. It's the question of the rule of law, and our fundamental Republican principles are at stake. With that, let's introduce our next speaker, Bill Conklin. Just a word about Bill. He's a former school teacher. He has a master's in communications, speech communications. He has spent 25 years researching the Internal Revenue Code. He has defeated the Internal Revenue Service 6 times in published wins in the 10th Circuit Court of Appeals. Bill has written the book, Why No One is Required to File Tax Returns. Bill has assisted individuals in hundreds of civil tax cases and has worked on dozens of criminal cases with various tax attorneys. Mr. Bill Conklin.
Thank you very much. It's really exciting to get an introduction by an IRS special agent. When Joe called me up, he said he was a special agent from the IRS, and I said, boy, this is interesting. You're the first one that ever admitted you were one of those guys. I've had them in my house before. They pretend like they're some poor taxpayer and try to get me to say things, you know. The last one I had, I sent him to the most expensive tax attorney in town to get help. You know, a little over 200 years ago, there was a guy named Thomas Paine who helped to cause the American Revolution. And you know how he did that? He published a pamphlet called Common Sense, and he got about 30,000 copies out. Now, there was only a few million people in the country that time, so that was a very large number of pamphlets considering the population. He got out information, and he caused a revolution. Now, what's been one of the biggest problems that we've had in terms of getting out information? Well, the press in this country and the media in this country tend to pick and choose their issues. And it's very difficult to get issues that are a little different or, you know, like a little questioning into the forefront. But do you know what happened a couple of years ago? The Internet came out. And when the Internet came out and really got going, I got an idea. I said, you know, I think I'll take some inspiration from this guy, Thomas Paine. And so what I did is I took my book, Why No One's Required to File Tax Returns, and I put it on the internet, and everybody in the country can download it at no charge. Right now I'm getting 1,000 hits a day. Okay? 1,000 people a day are looking at my book, and a lot of those people are downloading that book. So the first thing I want to tell you, everybody grab a pencil and a piece of paper. When you are done here and you're ready to look on your computer, go to www.anti-irs.com. That's www.anti-irs.com. And I want you to check my website out, download that book, make copies of it, and pass it out to everybody that doesn't have a computer. Do you know what would happen in this country if 100 million people would read my book this year? Do you know what would happen? The income tax would end, because my book proves, thank you, my book proves beyond a doubt that there's a severe problem with a federal income tax, and that the United States government is ignoring the Constitution and giving us all kinds of doublespeak to keep the income tax in place. Now, if 100 million people understood that, there might be 100 million people that don't file tax returns next year, and the income tax would come apart, and it would have to be changed to a more fair and just tax system. And everybody who gets on my website and reads that book will have the information in their head to understand what we need to do about this. So that's the first thing we need to do. It's going to be an easy, peaceful, simple revolution. And the reason it's going to be so simple is because filing tax returns is voluntary. And I'm going to prove that to you in this speech. It was 1976, which was the 200-year anniversary of the Declaration of Independence. I was walking around the block near my house, and there was a little garage that had a big sign on it that said National Tax Strike. And I walked in there, and man, there was some of these kooky old guys. You know, they were about the age I am now. And they were propounding these incredible ideas. And I said, man, I don't believe this stuff. Could this really be true? Well, I was a school teacher in those days, and I needed a little bit of extra intellectual stimulation, so I started hanging around the law library at night, and I started reading up on stuff, and you know what? I found out that there are some severe problems with the federal income tax. And so I wrote an article, and it was published in a local Denver newspaper. And 2 days later, I got a big, nasty-looking letter from the IRS auditing me with a TCMP audit, a Taxpayer Compliance Measurement Program audit. I was a little teacher who made $12,000 a year, and I had no deductions, and these guys were giving me an audit. Why was that? They were auditing me to punish me for exercising my First Amendment right. Now, what kind of a country do we live in? I make a criticism, a valid criticism of the federal government, and I get punished with an audit. So I got a little upset. I didn't know what to do about it at first, and I went to a tax attorney, and he looked at it, and he says, well, I'll go to the audit for about $2,000, and I thought, for $2,000, that's like how much money I make in 4 months. He wants 4 months worth of my salary so that I can go defend the fact that I gave the other 6 months of it to the IRS. And what do they want, the last 4? So I was upset. I didn't know what to do. So I started looking around, and I found some guy who had just graduated with his master's degree in tax law, and he was interested in getting some experience. He'd written his master's thesis on the Anti-Injunction Act, which is a law the government has to protect us from suing them. If they mess around with us on the tax system, they have this protection in the law. And he wanted to see what we could do. So we sat down and we wrote a lawsuit. And lo and behold, the lawsuit did get kicked out because of the Anti-Injunction Act. However, what the IRS had done, and you can read about it in my book, what the IRS had done is they had written a very nasty letter stating that they were going to take certain actions. Well, the federal court, the Court of Appeals, said that in order to take those actions, the IRS had to issue a summons first and follow summons procedures. And they said, it's true, Conklin can't file this lawsuit because of the Anti-Injunction Act, but the IRS can't do what it wants to do anyway. So I got an injunction, essentially, because the IRS couldn't turn around and do what it was going to do without issuing the summons. Later on, I had 5 more related wins in the 10th Circuit Court of Appeals. I tied the IRS up for over 20 years on that audit. I cost them probably millions of dollars. Just imagine right now, the IRS audits 2 million people a year. What if every single person who got an audit notice next year refused to go into the audit and filed a lawsuit instead? Can you imagine all the IRS auditors would be twiddling their thumbs, district counsel and the United States Attorney's Office would be completely buried and the income tax system would be enforceable, and all you're doing is taking advantage of the rights you have as United States citizens. And you know what? It's easier to file those lawsuits than it is to fill out a tax return. That's how ridiculous it's gotten. The other day I was riding my bicycle up Glenwood Canyon, and I stopped to talk to some guy. Glenwood Canyon's in Colorado. Far cry from Washington, D.C. And what happened was this: we started talking, and this guy says, well, what do you do? And I says, well, I wrote a book called Why Nobody's Required to File Tax Returns. That's all I have to do. I mean, you say that to anybody in the country, and you're going to get a speech. So I sat there, well, what's this guy going to say to that? That I'm a kook, or is he going to say I'm cool? So the guy says, he says, I'm an attorney. He says, tell me a little bit about this. So I told him about it. He says, well, I'm not a tax attorney. He says, but more power to you. He says, I spend hundreds of hours every year trying to figure out this tax system. Somebody's got to do something about it. Now, you know, 25 years ago when I said stuff like this, everybody thought I was a kook. And now there's even IRS special agents that don't think I'm a kook. Well, I really got into this, and I started researching, and I filed a lawsuit against the federal government. I knew there was a judicial conspiracy to protect the income tax. And so I figured out a kind of lawsuit I could file that no matter what the court said, I'd have something I could say about how they made a mistake. So what I did is I gave the IRS power of attorney to file all future tax returns for me if they could do it without waiving my Fifth Amendment rights. And I sent them a tax return that was filled out, and the only thing it didn't have on it was my signature. And the IRS fined me $500 for filing a frivolous tax return. I followed the procedures. I paid. And I filed a claim for a refund, and when it was denied, I filed a lawsuit in federal court. The judge had a motion hearing on my motion for summary judgment, and he said to me, Mr. Conklin, there's something I have to tell you that's fatal to your case. And I said, what's that, Judge? I thought he was going to tell me that I was, my argument was bad. No, he didn't say your argument's bad, Mr. Conklin. He said, Mr. Conklin, what's wrong with your case is that you're asking me to overturn the federal tax system, and I'm not in a position to do that. Well, of course, Judge, you might lose your posh job if you did something like that. No, I didn't say that. Well, I just listened to him, and 5 years later, he finally came out with a written opinion. I waited 5 years for that. Can you believe that? So 5 years later, he comes out with a written opinion, and he says, Mr. Conklin misunderstands the nature of the Fifth Amendment. He said, the Fifth Amendment applies only to compelled testimony, and therefore Mr. Conklin's wrong. It obviously doesn't apply to tax returns, since tax returns aren't compelled testimony. Well, now, come on. If you've ever looked in the dictionary, if something's not compelled, it's voluntary. Now, the IRS knows that it's voluntary, by the way. And what eventually happened, then I took that one up to the Court of Appeals, and the Court of Appeals sanctioned me $6,000 for raising the frivolous appeal that we are required to file tax returns. You see, I appealed that judge and said, Judge, you're wrong. It is compelled testimony. And the Circuit Court of Appeals didn't even read my brief. They just fined me $6,000. I took it to the Supreme Court, and the Supreme Court denied me certiorari, but that's common because they only hear about 1% of what's presented to them anyway. You're not going to get a chance to bring a case to the Supreme Court that's going to overturn the federal tax system, and that's why we have to put this in the hands of the people and tell the people vote. You know what happens? There's a lot of people that don't vote in this country. But you know what? An amazing amount of people on April 15th vote in favor of the federal income tax. So why don't you just quit voting? Don't send your ballot in on April 15th. Well, what does the IRS say about this? I went through the Internal Revenue Manual. It's a great big huge book, it's so big that if you tried to pick it up, it'd break your back. And I went through this manual. This is before they had computers, that would do this for you. And I looked through the whole thing, and I found the word voluntary many times. Listen to some of these. Chapter 6200 at 6210 states that, quote, it is the goal of the Internal Revenue Service to encourage and achieve the highest possible degree of voluntary compliance with the tax laws, unquote. Chapter 100 at 110 states that, quote, The primary mission of the taxpayer service is to promote voluntary compliance through education and assistance to taxpayers. In Part 4, under Section 6810, Taxpayer Service, it is stated at 1331(1)(f) that, quote, returns are voluntarily submitted by taxpayers. Why doesn't it say returns are submitted by taxpayers? Why does it say voluntarily submitted? When you add an adjective or an adverb or some sort of modifying word in a sentence, it's to add meaning to the sentence. Why would they need that word unless voluntary meant voluntary? In Operating Techniques and Reporting Section 6810 at 1391(1)(a), the manual states, quote, securing a valid voluntary income tax return from the taxpayer. In the section on IRS policy statements at P484, the manual states, quote, the purpose of the criminal tax investigation is to enforce the tax laws and to encourage voluntary compliance. In the general section at 422.65(3), it said that, quote, when a person indicates that he or she will voluntarily comply but requests that he be served, they're talking about a summons. And obviously the word voluntary means voluntary there, because if the person doesn't voluntarily accept the summons, then he has to be served by the marshal, by the United States Marshal. Okay? So now does the word voluntarily mean something different in that sentence than it means in the previous sentences describing tax returns? In the automated collection function procedures at 5535(4), the manual states that the IRS may file returns under 6020B if the returns are, quote, not filed voluntarily. Okay? Voluntarily, by the way, in Webster's dictionary means, quote, brought about by one's own free choice, given or done of one's own free will, freely chosen or undertaking, arising in the mind without external constraint, spontaneous in law, action done without compulsion or persuasion. Now, you know when you get your tax return in the mail, they send you a blank tax return in the mail to remind you to file one? You know, there's a lot of summons case law, especially in the last few years. And there's a case law, I believe it's in the 11th Circuit, called the Argomains case. And in the Argomains case, this guy took the Fifth Amendment when the IRS asked him questions. He went to a summons, and you know, if the IRS gives you a summons and you don't show up, they can take you to court and get the judge to order you to answer the questions, and if you don't answer them, the judge can hold you in contempt, and he can put you in jail until you answer those questions. And you know, federal judges have an incredible amount of power. They can even put you in jail criminally and civilly. They've got two different ways they can approach it. And the law gets pretty complicated on it. So the thing is, you can go to jail if you don't answer these questions. But do you know what? Taking the Fifth Amendment's an answer to the question. So if the IRS says to you, did you bring your books and records, you take the Fifth Amendment, and according to Argomains and other cases, you have a right to do that, and the IRS cannot enforce that as long as you do not admit that you have books and records. But yet, the government states filing tax returns is voluntary, and at the same time turns around and indicts people for not volunteering to create the illusion that we are required to file. What you've got is unbelievable subterfuge. You have a system where the government outright, on one hand, tells the truth, and on the other hand, indicts people in order to make people perceive that there's some sort of situation here that really doesn't exist. The purpose of the indictments, the purpose of what the IRS does, is to scare and intimidate people into voluntarily waiving their Fifth Amendment rights and giving the information to the government that can be used in criminal cases. And how do we know it can be used in criminal cases? Well, somebody like me has seen it firsthand in hundreds of different situations and in many thousands of hours of federal trials. But if you just look in the Privacy Act notice that comes with the 1040 instruction booklet, you'll see this, quote, we may give the information to the Department of Justice and to other federal agencies as provided by law. We may also give it to cities, states, the District of Columbia, the U.S. Commonwealth or possession, and certain foreign governments to carry out their tax laws. So, if you fill out a tax return, theoretically you could be prosecuted by the country of Iran for something if the United States government wanted to give them a copy of your tax return. Now, you know, our founding fathers put the Fifth Amendment into the United States Constitution for a reason. And for those of you that don't know what the Fifth Amendment is, The Fifth Amendment is the amendment that says, essentially, that we, among other things, it says, we do not have to give the government information that could be used in a criminal case. Well, my question for you to all ask your congressman is, do we waive our Fifth Amendment rights when we file a tax return? And if so, what statute requires us to waive our Fifth Amendment rights? Okay? If we do waive our Fifth Amendment rights, what statute requires us to waive our Fifth Amendment rights? Don't ask them whether you're required to file a tax return or not, because they'll just come up with some gibberish. Of course, they'll probably come up with gibberish in response to this question, too. And if we don't waive our Fifth Amendment rights, then why does the Privacy Act notice in the 1040 instruction booklet give us a Miranda type of warning? And for those of you that don't know what a Miranda warning is a warning that the police give to people, telling them what their rights are and whether they have to answer the questions or not. Another interesting thing is this, and Joe would be quite familiar with this. If a special agent from the IRS ever knocks on your door and he's investigating you criminally, the first thing that he'll do, or should do, is read you your Miranda rights. And then after that, anything you say, he can use against you criminally. Well, maybe the first question to ask the special agent is, after he reads you your rights, you say, well, if I was to have answered that question yesterday before you came here on a 1040 tax return, could you have used it against me? That'll make him think a minute. And by the way, if a special agent ever knocks on your door, don't talk to him, except maybe to answer that question, because he will become a witness against you in the tax case. And you know what? I have more than once seen government agents on the stand misrepresent the fact situation. And they are trained so well in their subterfuge that it's very difficult to deal with. I will tell you that government agents do not always tell the truth on the stand. And that's why when you say something, it can be confused and convoluted and messed around. So, don't waive your Fifth Amendment rights. And remember, be extremely careful about waiving your Fifth Amendment rights if you're considering filing tax returns in the future. Well, you know, I was so sure of my idea that I put out a $50,000 reward for anybody that can prove I'm wrong. And everybody who's watching today, I would love for you to apply for the reward. Because, you know, Melvin Belli, the famous palimony attorney in California a few years ago, did apply for the reward. And he said, Mr. Conklin, there is a way that you can file a tax return without waiving your Fifth Amendment rights. He said, here's how you do it. He said, you give an attorney power of attorney to file the return for you, and you pay him, and he'll pay the IRS out of the trust fund account, and then he'll file the tax return, and he'll sign it as the preparer of the return. And where it says your name, he'll just write in a code number. When the IRS calls up to the attorney and says, whose tax return is this, he'll take attorney-client privilege. Well, that's pretty good, Melvin, but here's a problem. What happens when the IRS proceeds civilly or criminally? Let's take, for example, the IRS proceeds criminally against the guy. Well, this would be a great sting operation against the IRS. Can you imagine the IRS spending 3 years investigating some guy criminally? And then it goes to trial, and the IRS presents their case, and the guy and his attorney just sit back there enjoying the game, you know? And then the guy gets to put his case on. And what does he do? He puts the attorney up on the stand, and the attorney waives attorney-client privilege and waives the guy's Fifth Amendment rights. And what does he say? He says, oh yeah, this guy filed and paid his taxes. Here's a copy of his tax return, and the IRS wrote a letter acknowledging they got it with this number on it. Well, there goes the criminal case. IRS just wasted 3 years. But the point is, what happened? The attorney waived the guy's Fifth Amendment rights in order to prove that the tax return had actually been mailed in, and certainly it wasn't filed legally and credited to the guy's account until the attorney did the testimony. So I said, Melvin, sue me. And I wanted to make sure he sued me, so I put an advertisement in a California newspaper that says Belli backs down, but he still didn't sue me. Now, I have thought, if anybody's interested in this, a great way to really cause the IRS trouble would be for about 1 million high rollers to go file this way. Let's say 1 million people in the United States filed and then wrote all kinds of letters to the IRS, you know, but they had an attorney file for them this way. Can you imagine the IRS does 100 criminal cases that year that go to trial, and every single one of them an attorney gets up and says, oh yeah, the guy filed and paid? Can Can you imagine how that would disturb the federal tax system? If 100 criminal cases won based on something like that? I'm serious. There's all kinds of really creative, neat things that can be done. So, what I want everybody out there to do, first of all, is to read my book and get educated. Secondly, get the information out. If you've got friends that don't have a computer, go down to Kinko's, print up 10 copies of my book and pass them out. It's copyrighted, but you've got my permission. Okay? If Kinko's won't print it out with the copyright on it, tear off the copyright page. But get it out there, okay? Get that book out there. Because you know what? We have a chance, because of the internet, for the first time in history, to do what Thomas Paine did 200 years ago. And we're going to change this federal income tax, but you know how we have to do it? Each one of us has to take responsibility for doing that. Don't go vote in favor of the income tax on April 15th. Do something. Make a change. I don't care what you do. At the very least, read my book, think about it, talk about it, because you know a grassroots movement in this country will change the federal income tax, and with the power of the internet and the power of getting information to the people without having to go through Random House or NBC News, without having to do that, with getting the information directly to the people, with that kind of power, we can make this change in this country. So let's do it. Thank you.
Wow. Thank you, Bill. Kraft, our next speaker, graduated in 1972 from Stanford University in Birmingham, Alabama, cum laude. Graduated in 1975 from Cumberland School of Law. In 1975, he was admitted to practice in Alabama, and he has been admitted to practice and argue before the U.S. Supreme Court and all federal appellate courts except the First and D.C. circuits. He has represented lead defendant Franklin Sanders in the longest tax trial in American history, involving some 26 defendants, and all defendants were acquitted. Mr. B. Kraft is the general counsel to the Wallace Institute. Board members D.B. Kidd, General Ben Pardon, and former Judge Bud Baxter. Let's give a warm welcome to Mr. Larry B. Kraft.
Thank you, Bob. I would like to make an advertisement right now, if I can, just taking this opportunity before this crowd and this national audience. If you would like to know more about the Wallace Institute, if you'd like to know more about what I have to say, there's two web pages that I would direct your attention to. One is D.B. Kidd's. And the URL for that is just simply devvy.com. And then, of course, my webpage, which is the Dixieland Law Journal, it's associated with a good friend of mine's webpage, Scott McDonald. He has the Fight the Fingerprint webpage. But ours can be accessed through, just simply type in networkusa.org. And you'll find a lot of information, both regarding the Fight the Fingerprint issue, as well as my views about taxation. Then if you run over to DB's webpage, you will find the Media Bypass article that came out yesterday regarding the Columbine shooting that DB wrote. It's now posted to her webpage. I really invite you to study those particular webpages. Now, it's been mentioned that our organization, the Wallace Institute, we have Jeff Metcalf, the host of one of the radio talk shows at KSO. We have General Ben Parton, my fellow Virginian, sitting over here in the room with us. He's a board member of the Wallace Institute. We named the organization the Wallace Institute not after some former governor in Alabama. We named the Wallace Institute, Davey's the one that picked the name, because my favorite movie, as well as hers, is Braveheart. And I think that the objective and purpose of the Wallace Institute is much like the words of William Wallace. If you're watching the movie, but at the first scene of the battle, you have some people that are trying to desert. Oh, we don't want to fight. What does William Wallace say? He says, well, you fight and you may die. Run and you'll live. At least a while. And dying in your bed many years from now, would you be willing to trade all the days from this day to that for one chance, just one chance, to come back here and tell our enemies that they may take our lives, but they may never take our freedom? And those words kind of bring up into me, they make me choke a little bit. And I think that the other people that are involved with the Wallace Institute agree with those words. Ours is a quest for freedom. Now, we've assembled today for the purpose of objecting to at least one thing that I think is anti-liberty, anti-freedom, and that is the federal income tax. And I would like to make a few comments this morning regarding some of the things I have learned by engaging in an almost 20-year study of the federal income tax. And I would like to repeat the words of Senator Elihu Root back in 1913 when they were arguing about the very first federal income tax, which, I've made copies of all of the acts regarding the income tax. And that first income tax couldn't have been 20 to 25 pages long. Today, this is half of it. But back then, Senator Elihu Root made a comment, which I think is particularly appropriate. He was talking about the complexity of the first income tax, and this is what he said. Well, I guess you will have to go to jail. If that is a result of not understanding the tax laws, I shall meet you there. We shall have a merry, merry time because all of our friends will be there. It will be an intellectual center. For no one has sufficient understanding of the income tax laws except persons who have not sufficient intelligence to understand the questions that arise under it. Now, let me just tell you, ladies and gentlemen, I think that is an apt description of both the law then as well as today. Now, let's talk about a couple of legal principles that I think that you need to understand in order for you to comprehend the argument that I would like to present for you today. First, how many people here believe, this may be an outstanding proposition, you may have never heard of it before, but how many of you believe that you can rely on the word of the government? Yeah. We should be able to rely on the government, as astounding a proposition as that may be. Let me give you an example, a case that illustrates that legal proposition. Reverend Cox, back during the Civil Rights era, was leading a protest in Shreveport. He had a whole bunch of his followers. Something happened the night before. Some of his people were arrested. They're jailed. They're going to be arraigned this bright early morning at the state courthouse. And he's leading a band of his followers down to the courthouse to demonstrate. Well, he was told by the chief of police that he could not demonstrate near the courthouse, and then the chief of police proceeded to tell him where he could hold his demonstration. Well, the prosecutor must have been looking out of the second floor of the courthouse and said, hey, I want to nail Reverend Cox. Proceeded to do so. The charges against Reverend Cox were demonstrating near a courthouse. But what's wrong with this picture? Reverend Cox had been told by the chief of police where to hold his demonstration. Reverend Cox went to trial, was convicted. The Louisiana Supreme Court affirmed the conviction, but the United States Supreme Court reversed and said, hey, look, it is reprehensible conduct on the part of the government for the government to tell you something and then turn around and deny it. And in this situation, Reverend Cox had been subjected to conflicting authority from the government. One had said he could hold a demonstration at a spot where he did, and then he was accused by another government official of violating the law. Let me give you another example. Mr. Albertini. Albertini was a fellow that liked to, out in the Ninth Circuit, protest against nuclear power. Out there in Hawaii, they do have those nuclear subs that pull into the Honolulu harbor, and he didn't like nuclear subs. Well, he would protest against them. One time during a protest, he was convicted, charged and convicted for violating some law regarding an anti-demonstration event. He appealed his conviction to the Ninth Circuit, and the Ninth Circuit came out and said, well, gee, he has a First Amendment right to do that. Albertini immediately, once he gets his decision from the judges, what do you suspect that he does? He goes out and engages in another protest against nuclear power on the submarines. In the interim, the United States government says, well, gee, we need to appeal this decision to the Supreme Court. The government did. The United States Supreme Court reversed. And now, Albertini, having relied upon the word of the government, having relied on the word of the courts, finds himself back in trouble again. Well, he was prosecuted, convicted, but this time the appeal before the United States Court of Appeals for the Ninth Circuit, the court said, well, gee, he relied, even though we were wrong, he could rely on the word of the courts. Now, those two cases, a part of a line of authority that says you can definitely rely on the word of the government, leads into this next proposition. What happens when the government gives you two conflicting voices? What happens when the government says yes, and what happens when the government says no? Well, a demonstration of this is the case of Miss Kritzer in the Fourth Circuit. Miss Kritzer, an Indian that lives down there, obviously, on one of the reservations in North Carolina, she was told by the Bureau of Indian Affairs that she could rely on their advice, and their advice was that she not file income tax returns to report the income that she made on the Indian reservation. Well, naturally, Miss Kritzer relies on this advice, but the IRS comes along years later and disagrees with the advice that she had gotten from a government agency, and she was prosecuted and convicted. And on appeal, the Fourth Circuit said, it is amazing. Look at this fact situation. We have the government saying on one hand that Miss Kritzer, this little lady caught in the middle, wasn't required to file returns, and then a government agency on the opposite end of the spectrum saying that she was required to file income tax returns. And this poor little old lady is caught in the middle, and because she received conflicting advice, to prosecute her constituted a due process violation. Now let me just tell you, ladies and gentlemen, with these legal principles, what I would like for you to understand is that based on what Bill Benson's discoveries have shown, that the American people are in fact being subjected to a monumental due process problem. It is far larger than the due process problem that was presented to Ms. Kritzer. Let me explain my position. As Bill told you, he checked out the ratification of the 16th Amendment. The government says, and we can rely on the word of the government says that 38 states ratified the 16th Amendment. Well, the constitutional threshold, since we had 48 states in the Union back in 1913, the bare constitutional threshold to adopt the 16th Amendment was 36 states. It appears to me that if we merely eliminated 3 states, we would have a valid position that the 16th Amendment had failed to be ratified. Well, let's go over those quickly. I will kind of recover some of the grounds that Bill was talking about. One of my favorite states to show that as an example of a state that failed to ratify the 16th Amendment is that of Kentucky. You heard Bill a few moments ago talking about what Kentucky did. February 8, 1910, the proposition. Now, the House had, before that time, had adopted the 16th Amendment, and obviously they had mailed evidence of the ratification by the House in Kentucky to Philander Knox in Washington, D.C. Why do we know that? Because that is part of the documentation that Bill discovered down at Archives just down the street. Well, what did the Kentucky Senate do? Well, the Kentucky Senate on that date voted on the amendment, and the government claims, the Kentucky Senate adopted the 16th Amendment on that date. But when you go to the legislative journals, you see, as Bill said, there were 9 votes in favor, 22 opposed. Now, I don't know about you, but I think that we can definitely consider that it is quite obvious and crystal clear that Kentucky did not ratify the 16th Amendment. So now we're down from 38 to 37. Well, let's take another one of my favorite states that I like to talk about, Oklahoma. What did Oklahoma do? Very similar to Kentucky. One house of the Oklahoma legislature ratified the 16th Amendment, and it was perfect. However, when the action of that body, the resolution, was sent over to the other body, maybe the Senate, what they did is they deliberately changed the wording of the 16th Amendment. Now, the 16th Amendment had a very clear purpose. In 1894, the United States Supreme Court had struck down as unconstitutional the 1894 federal income tax. Because of the decision in this, what we call the Pollock case, the 16th Amendment had been proposed to kind of circumvent the constitutional problem created by this decision. So in 1913, it was alleged that the 16th Amendment was ratified. It reads, there's 30 carefully drafted words. Congress shall have the power to lay and collect taxes on incomes from whatever source derived, without apportionment among the several states and without regard to any census or enumeration. Now, that's a whole bunch of words. That's 30 words. They have a very specific meaning. However, the Oklahoma legislature came out and changed the amendment to read the exact opposite. Rather than requiring or eliminating the apportionment requirement for income taxes, the Oklahoma legislature demanded that income taxes be imposed and subject to the regulation of apportionment. Now, that's kind of complex language. But it clearly demonstrates that you cannot consider, a rational person cannot consider that Oklahoma ratified the amendment because it means the exact opposite of what the 16th Amendment itself says. Now we're down to what, 36 states? Well, let's just pick another state out of the blue, California. California deliberately engaged in modifications of the 16th Amendment. If you sit down and read what they allegedly adopted, besides the defects that Bill's talking about, there's no evidence of a vote by the California legislature. You cannot make sense of what the California resolution allegedly adopting the 16th Amendment means. It appears to be the product of a drunken sailor. Now, that brings us down to 35 states. Do we not have an argument? Remember, the government says it's not some flaky idea I concocted. It's not a wild theory that Bill Benson concocted, but the government says the power to tax incomes is predicated upon the 16th Amendment. Well, let's accept their proposition. If they say that the taxing power is predicated on the 16th Amendment, then if we have evidence that discloses the failure of the American people, the failure of the states to ratify the 16th Amendment, wouldn't it be logical to argue that there is no power to tax? Yes, very logical. Well, now I have just shown to you very quickly that 3 states failed to ratify the amendment. And it looks like to me we've got a very solid legal argument that we can go to court with and say, hey, you can't convict these people. You can't impose taxes on these people. Well, that's exactly what we did. Bill Benson finished the state of Washington December 22nd, 1984. We assembled, he and I and another friend of ours assembled on December the 28th, 1984 in Kokomo, Indiana, and we made a decision. The first case we're going to raise this issue in is the Janie Ferguson case, which was then set for trial January the 15th of 1985. New Year's Day, 1985, I draft the first motion to attack the ratification of the 16th Amendment. We go to court on January the 15th, 1985. Bill comes to court with 8 or 9 states that are defective, and we present our evidence to the judge. And between that date of January 15th, 1985, all the way up through the next 3 years, in a variety of cases across the country, we raised this question of the non-ratification of the 16th Amendment, and guess what we had in the way of a response from the American federal judiciary? Before I tell you what they did, let me tell you what the states have done with similar issues. Like in Alabama, if we have an argument, a legal argument, that an amendment hadn't been ratified, we can march into court and our courts will consider that question. We did it back in 1983, this case called Alabama against Manley. We attempted back in 82 to totally redraft the Alabama Constitution with an amendment. And the issue was raised in Alabama at the time, can we do that? Is it legal? And the Alabama Supreme Court said, no way, Jose. Well, you know, there's a wide variety of state courts that have likewise similarly handled questions of this nature. So the states obviously can tell you that they can consider judicially the question of an amendment to a constitution. Well, we received the exact opposite answer from the federal courts. The federal courts disclaimed any authority to deal with this question of the ratification of the 16th Amendment. Now, I can obviously understand the reasons why. When you take a look at the amount of receipts that the federal government derives from the income tax, you know, it takes a very brave man to sit there and say, this power is out the window. And of course, that was the reception that we received in a wide number of cases where we raised this issue. The courts said, oh, we can't do anything about this. In essence, what the courts told us to do is take this silly little problem down the hall to Congress. They are the guys that will resolve this question. Well, Bill Benson happened at the time to live 2 doors down from a lawyer by the name of Marty Russo. At that time, that lawyer, Marty Russo, was a representative in Congress. He was Bill Benson's representative in Congress. And Bill one evening went down and knocked on Marty's door. And Marty came to the door and said, well, Bill, what can I do for you? And Bill proceeds to outline his whole argument in his book. He says, I've got all this evidence here. Marty, we've been to court. Guess what? You as a lawyer should know what this means. The courts are saying that this is a political question. And Marty thinks about it for a minute, and he acts like the courts. Whoa, I don't want to have to resolve this question. This is not a political question. It's one for the courts. And they must decide the question of whether or not we have an amendment. Now, I don't know about you, ladies and gentlemen, but I find that this situation that we've got here in America to be deplorable. Not only has Bill been told by his congressman that it's a political question, it's a judicial question, one for the courts. This man right over here with the gray beard, John Justice, back in 1987, and Bill, they sent out Volume 1 of Bill's book to all congressmen, all federal judges, all U.S. attorneys, all the governors, and he asked them, under our right to petition the government for redress of grievances, he asked for action from the political branch on this question. Do something about it. And the voice that we received back, the replies were, we won't do anything about it. It's a question for the courts. Now I ask you this. You know, the United States Supreme Court says that we have a right to know whether a law exists. It only makes sense. We have the evidence that can prove that the 16th Amendment was not adopted as required by the amending provisions of the United States Constitution. You can rely on that. And we presented this issue to the courts, and they point their fingers to Congress, and Congress points their fingers back to courts. And those are the only two branches that have anything to do with ratifying an amendment to the United States Constitution. And I ask this simple question. Aren't we, if we are entitled to know whether or not a law exists, are we not being subjected to a monumental due process problem very similar to that faced by Ms. Kritzer? Remember the lady that was told she doesn't have to file income tax returns by the Bureau of Indian Affairs? A couple of years later, the IRS says, no, she was wrong. She was required. Are we not being subjected to an identical situation? Is this not a monumental due process problem that is being presented to all of the American people as a result of the acts of Congress and the federal courts? But not only does the American people face this monumental problem, let me kind of really quickly summarize another problem that we all have. You know, there's two types of taxes that the United States Constitution authorizes Congress to impose. One's a direct tax, one's an indirect tax. It's only logical that the income tax should fall within one of those two constitutional classifications. The amazing proposition is that if you sit there and read the decisions of the federal courts, what do they say? Where does the income tax fit constitutionally? Well, some federal courts say, well, gee, it's a direct property tax. Other federal courts say the exact opposite. It's an excise tax. When you get down to the state level, the states are the exact opposite, but you still see the same problem. Most of the state courts say an income tax is an excise tax, but again, that's a rule subject to exception, because the minority view is that it's a direct property tax, which incidentally is the majority view at the federal level. Now, doesn't that make sense? But the only thing that makes sense is this, that here in America, our system has told the American people that if you look into the constitutional foundation for this particular tax, the only thing that you will confront is uncertainty of the law, and uncertainty of the law creates a due process problem. Now, I guess my time's approaching a conclusion here in a moment, but I want to ask you this simple question. You know, the folks that have formed the Wallace Institute, we want to do something to correct the ills in America. I think that there are a tremendous number of problems that are created by the government. And if we want to increase liberty and freedom in this country, we're going to have to get up off of our comfortable rear ends and do something about it. But I've taken my own personal survey. People call me up. They might have a tax problem, or they're contemplating, these questions regarding the income tax. And the majority opinion or view or goals of the people with whom I talk are these. Well, I just want the IRS to leave me alone. I just don't want to be bothered by the government. Well, there's a class of people that these classes of individuals were best described by one of our founding fathers back at the time this country was founded. Those are the people that want basically something for nothing. They don't want to protect their liberty. They want somebody else to do it. And they are best described as those individuals that match this description. If ye love wealth better than liberty, the tranquility of servitude better than the animating contest of freedom, go home from us in peace. Crouch down and lick the hands that feed you, and may posterity forget that ye were our countrymen. Now, those are the people, once you go out and identify who they are, the best thing to do is move on. If we identify an opposite class of people, those who are willing to help us correct the ills of America, we can do it. And I would suggest there's the great potential that within the next 5 years, if the American people will exercise their political power, if they will confront government and they will do it actively, We can change America. And we need to become people like Patrick Henry. You remember what Patrick Henry had to say. Is life so dear, a peaceless sweet, is to be purchased at the price of chains or slavery? Forbid it, Almighty God. I ask not what course others may take, but as for me, as for the other members of the Wallace Institute, give us liberty or give us death. Now, if we go out with that same attitude of Patrick Henry, we can change America for the better. Thank you very much.
Well, thus far we've heard some very overwhelming, very powerful evidence that calls into question the validity of the income tax amendment, whether the 16th Amendment was in fact ratified. We've also heard some very powerful evidence that even if the 16th Amendment was valid, there is no statute. Congress has passed no law compelling people, most of us, to file and pay taxes, direct taxes. So if the income tax goes down, because the people never really did ratify the income tax amendment, which means we're back to the original Constitution, unamended. We're back to, for instance, Article 1, Section 9, Clause 4, which gave to Congress the power to tax the people in two ways: with indirect taxes, such as excise taxes, taxes on cigarettes and liquor and other things that we could avoid as an indirect tax. The Constitution also gave Congress the power to impose direct taxes, taxes we could not avoid, like an income tax. But Congress, when the people gave Congress that power, in 1789, they did so with an important condition. Any direct tax that Congress was going to impose on the people had to be apportioned, meaning if California had 10% of the people, California had to come up with 10% of the revenue of that particular tax. Brilliant provision by the forefathers, making it extremely difficult for the federal government to impose direct taxes on us that we could not avoid. Direct taxes were not imposed on Americans. Congress tried in 1894. They passed an income tax without apportionment, ignoring the Constitution. The Supreme Court, as Larry has pointed out, struck it down in 1895 in the Pollock case, saying it's not apportioned. It's unconstitutional. The forces who wanted an income tax didn't rest. Eventually, in 1909, they prevailed upon Congress and got Congress to pass a proposed amendment to the Constitution to basically repeal the apportionment provision, allowing Congress to impose a direct tax on the people without apportionment. That became the proposed, or the purported 16th Amendment, but it required 3/4 of the states to ratify it. And as we've learned, there's very strong evidence that Philander Knox, the Secretary of State in 1913, committed fraud in proclaiming that it had been